Hello. Welcome to Crime in Court. My name is Heather, and this is another Delphi update. So, I'm not going to be reading the Frank's memo, which is a separate series I'm doing. Here I'm the prosecutor for the Delphi case, Nick McLeland. He actually just came out with this document yesterday. He filed it with the Carroll Circuit Court at 4:30 p.m. So this motion is to find Brad Rosie and Andrew Baldwin in contempt, which basically means for the court to rule that they disregarded the court's orders, and potential sanctions or something might, ensue based on, if they're found to have done the things that they're accusing them of doing in here. So let's get started. It's a 9-page document, so let's dive in. All right, so verified information of contemptuous conduct. Comes now the state of Indiana by prosecuting attorney Nicholas McLeland, and brings to the court's attention, as an officer of the court, verified information of contemptuous conduct by defense counsels Brad Rosie and Andrew Baldwin, pursuant to IC 344735D, whatever statute or law that is. All right, so the state would ask the court to order Brad Rosie and Andrew Baldwin to appear before this court and show cause if there be any reason why they should not be held in direct contempt for violation of this court's orders. So for violating this particular Judge Goal's orders. The state would ask that the court consider the following. Number 1, that both Brad Rosie and Andrew Baldwin were appointed by this court to represent the defendant herein as public defenders on November 14th, 2022. Number 2, that a hearing was held on November 22nd, 2022 to resolve preliminary matters the same day the state of Indiana filed a motion for an order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication, commonly referred to as a gag order. Number 3, that the court took the state's motion under advisement, but in an in-chambers conference, defense counsels Brad Rosie and Andrew Baldwin refused to agree to the state's motion, stating that such an order, i.e. the gag order, was unnecessary because they had no intentions of discussing the case to the public. Okay, what is that? Okay, I don't know why that's important. Number 4, that on December 1st, 2022, the defense put out a press release that included extrajudicial statements by means of public communication that commented on the case to the public and to the media, including commenting on the investigation by law enforcement, the evidence discovered against the defendant, and presenting evidence that they believed proves the defendant's innocence. I don't see anything wrong with that, but there was a court order, a gag order. The information released would have been in direct violation of the gag order that the defense would not agree to, and which the defense stated was unnecessary because they were not going to discuss this case in the public or the media. The press release is herein attached as Exhibit 1. So the court put in a gag order on November 22nd, 2022, according to Prosecutor Nick McLeland. On December 1st, the defense put out a press release that disseminated information to the public that would have been covered by that gag order, basically. I'm not exactly sure what they said or how it violates the gag order, but um, Nick thinks so. All right, so number 5, that the press release contained multiple comments of the kind presumed to have a substantial likelihood of materially prejudicing, I can't say that word right now, an, an adjudicative proceeding in this matter. I have an issue with that too, because the media comes out hard on, this is the person the suspect in custody, and from then on they treat him like he is a monster. So that's why can I not say that word right now? It is prejudicial towards the defendant, not all the media and everything that comes out, and the fact that, people are able to do some sleuthing and find out things about Richard Allen and, do digging and everything on this person and act like he's this monster before he's even convicted. That part is just gross to me, but it's possible. And I mean, it's possible that what they released on the press release, they didn't feel really violated the court order. Basically, well, let's keep going, and I'll give my thoughts more at the end. All right, so number 6, that the court entered an order on December 2nd, 2022, granting the state's motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication in whole without a hearing. The order directed the attorneys not to comment on this case to the public or the media directly or indirectly by themselves or through an intermediary in any form. The court reminded counsel at that time that they were bound by rules of professional conduct, Rule 3.6, about trial publicity. This order is commonly referred to as the gag order. The court commented that this order was put out in response to the press release by defense counsels Brad Rosie and Andrew Baldwin. So as a means to shut them up, Gull put out a gag order on them. So the gag order originally wasn't done, or what? Go back to this. So there was a hearing on the 22nd. I'm confused. So if they put out the statement December 1st and the gag order wasn't done until December 2nd, how have they been negligent? I'm very confused. They didn't do it. They didn't violate an order because the order wasn't placed yet. It appears that they didn't do it until December 2nd. So I guess they talked about having a gag order in the November 2nd hearing, and that's when when Allen's attorneys said, we don't need it, we're not going to be discussing the case, so she didn't put the gag order in. So technically they didn't do anything against the court's orders. If the court didn't order it until December 2nd, I'm sorry. It's just not how we go. We don't go retroactively to punish people. I just don't understand that. Anyways, number 7, that sometime in December of 2022, defense counsel Andrew Baldwin violated the court's gag order by sending an email to Brandon Woodhouse containing an outline of discovery, including the names of juvenile witnesses. Brandon Woodhouse is not an attorney on this case and is not involved in this case in any capacity. So what that's referring to is at some point Andrew Baldwin accidentally sent something to the wrong Brad. Or the wrong person in his Outlook, like the wrong name came up. Brandon Woodhouse came up probably instead of Bradley Rosie. And he was probably giving it to Brad to review. And all it was an outline. There was no secret information. So I don't know why they're so upset about that, but I guess that's misconduct on their end. I guess Nick McLeland has never made a mistake. All right, so number 8. That further, defense counsel Brad Rosie and Andrew Baldwin failed to notify the court or the state of the dissemination of information in this case to an unauthorized recipient and intentionally withheld that information from the court and the state by asking Brandon Woodhouse to delete the email. I don't think asking him to delete the email is trying to hide it. He should delete it because it's not meant for him. But I think Nick McLeland is jumping to conclusions there. I don't know. Kind of a leap, in my opinion. Number 9, that this leak of information, this is not a leak. I'm sorry, that's not a leak. He accidentally emailed somebody. That's not a leak. This leak of information was not discovered until the state uncovered it on Brandon Woodhouse's YouTube channel in March of 2023. Further, it was discovered that Brandon Woodhouse has disseminated the information to several other people, and his YouTube channel was viewed by multiple viewers. I've never heard of this guy. That doesn't mean that he doesn't have a big channel, but so what? All they had was an outline. That doesn't mean anything. This dissemination of material from the case is a violation of the gag order that directly relates back to defense counsel. It was a mistake. It wasn't like he was giving it out on purpose. I don't understand why. I don't know. Whatever. Continuing on. Number 10, that on February 13th, 2023, the state filed a motion requesting a protective order governing discovery in an effort to prevent the defense from disseminating evidence in this case to people outside the case and or the public. So they felt it was bad enough that the state wanted, they filed a protective order. He didn't even do anything wrong, in my opinion. I mean, it was a mistake. What do you guys think? Have you ever sent an email to the wrong person? I mean, I've done it. We've all done it. It's not like he was, and it was only an outline. Calm your butt down, Nick McLeland. All right, so 11, that on February 17th, 2023, the court granted the state, did I miss one? No. The court granted the state's motion and put in place a protective order setting forth very restrictive rules to prevent dissemination of the discovery in this case to the public or to anyone not involved in the case. 12. That in October 2023, the state was made aware by the families of the victims that crime scene photos were leaked to the public. Indiana State Police began an investigation into how the photos were leaked. It became immediately obvious that the leaked photos came from the defense. On September 18th, 2023, the defense filed a Frank's motion with a memorandum in support. That is what we're reading in parts because it is 136 pages long. We have just recently done part 3. I'm about to record part 4. So if you are interested in that Frank's motion, please go check those videos out. We do readings of the entire motion of the Odinists and how they might be involved, and that's the Frank's memo. All right, so the memorandum described the crime scene in gory, graphic detail. As part of that memorandum, the defense attached exhibits that were provided in hard copies to the state and the court. Some of the exhibits were side-by-side photos that the defense created and photos of the crime scene that the defense had altered. These photos were the photos that were leaked to the public. So they're saying that that's a leak in a public document? I mean, a public court filing? That's not a leak. I'm sorry, that's just not a leak. So they're claiming that they leaked their own photos by putting it in a memo and the public got to see it. So it's a leak. That's not a leak. Number 13. The investigators were led to a podcaster who said he got the pictures from an individual that he knew. The investigation led officers to determine the podcaster got the photos from a man that he knew who got them from Robert Fortson. Robert Fortson received the photos from Mitch Westerman, who is tied to the defense. 14, that on October 10th, 2023, defense counsel Andrew Baldwin stated on a conference call with all parties that a trusted confidant by the name of Mitch Westerman stopped by his office to visit, snuck into his conference room where all the discovery was in the case, and uncovered or unsecured and took photos of crime scene pictures. Defense counsel Baldwin stated that this occurred without his permission and that the pictures were stolen. Ironically, this was hours after investigators spoke to Fortson and determined that Mitch Westerman leaked the photos and he was the connection to the defense. So they're insinuating that the defense was hiding it, but prove it. I don't know. Prove it. Number 15, that the investigation by the Indiana State Police revealed that Mitch Westerman previously worked for Baldwin and was a person Baldwin trusted. In an interview with Indiana State Police, defense counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Franks memorandum to review. Defense counsel Baldwin also stated that he gave the Franks memorandum to another civilian to review. Franks memorandum and exhibits contained protected discovery information that included very sensitive crime scene photos that were, quote, leaked by Mitch Westerman. Specifically, the investigation revealed that Mitch Westerman gave the photos to an individual named Robert Fortson, who then passed them on to the individuals who distributed them throughout the internet. So who distributed that? Was it the podcasters who distributed them? Because Ms. Robert Fortson gave them to the podcasters, so I don't know. I'm not insinuating that the murder sheet or whatever podcast didn't, that they did it, but it's kind of the way that it's written, it kind of makes it seem like that. But it's not. I mean, they're not insinuating that. All right, so number 16, that on October 12th, 2023, defense counsel Brad Rosie submitted a letter to this court admitting that both he and defense counsel Andrew Baldwin had agreed to store the discovery in the conference room in defense counsel Baldwin's office. Further, defense counsel Rosie admits that Mitch Westerman had access to the conference room and took the photos. Finally, defense counsel Rosie admits that it was negligent on the part of defense counsel to allow Mitch Westerman alone in the office where sensitive discovery material was stored. And I'm going to chime in here because Mitch Westerman was a trusted friend of Andrew Baldwin's, and he used to work for Baldwin. He used to be a consultant. So why would he not trust him and think that Mitch Westerman in a room alone with discovery for a case that he's working on, why would he think in any way that his friend, his trusted friend and fellow colleague, would take the pictures behind his back and disseminate them? He wouldn't. You wouldn't think that either. But they're trying to say that it was negligent on his part to let Mitch Westerman alone in the office with these materials. And maybe it's negligent. I'm not sure. But when it's someone that used to work for you and a trusted friend, I don't know why you would think you would need to lock the room from them or keep them out of a room that had sensitive material. I think he was just stabbed in the back by a friend, and it could have been anybody. Like, it could have been anybody that worked there and had done it, you know? I mean, some, like a clerk or somebody. I'm not saying that, but I'm saying like anybody who had access to that law firm, the office, who had access to a conference room could have done it. It's not just because it's Mitch Westerman and it's Brad's friend. Like, it could have been anybody. So I don't know. I'm sorry, it's Andrew's friend, not Brad's. Anyway, so admitting to this court that they are in direct contempt of the court's orders, Rosie accepts responsibility for a lapse in security that caused the photos to be leaked. And when I say they were leaked, they weren't even leaked to everybody, and like, I never saw them. A lot of people did not see them. They are, I think it was a very controlled drip, not a leak. I think, is that what Bob Motta calls it from the defense diaries. It's not a leak, it's a drip. All right, number 17. That on October 18th, 2023, Mitch Westerman submitted an affidavit to this court stating that he, in fact, went into the conference room of defense counsel Andrew Baldwin and took pictures of discovery evidence without the permission of defense counsel Baldwin. So, I mean, the guy was man enough to man up about it and say, yeah, I did it, and he had nothing to do with it. So that's good. And he did, what was he sentenced to? I don't think he went to jail for it, but he was sentenced to something. He did go and receive justice, whatever that was, for his crime in taking these photo leaks. So anyways, 18. The investigators were able to retrieve messages between Robert Fortson and another individual that showed that Robert Fortson had detailed real-time knowledge about when evidence was submitted to the defense and the contents of that evidence for weeks before the photos were leaked. Fortson also knew the actions defense took in trial preparation, leading law enforcement to believe that this is not a one-time act of one person, but a consistent leak of information and discovery in the case. Yeah, but what if it was all this Mitch Westerman who was leaking it? And he was trying to get the information from Andrew Baldwin because Andrew Baldwin confided in him and trusted him and let him read the memorandum that he wrote. You know, I mean, you trust your friends. So this guy could have been, his friend, Mitch, could have been going and giving all this information. The investigation showed that Westerman would get information about the case and then give it to Fortson, who would distribute it to other individuals. Exactly what I was just saying. It's not Brad or Andrew's fault. It's this Mitch Westerman guy. Blame him. He's the one that took the actions and actually did it. Number 19. The investigators attempted to interview both Mitch Westerman and Robert Fortson, each of which declined. So neither of them wanted to be interviewed. Okay. What do you guys think about that? Let me know in the comments below. And please, before I forget, don't forget to like, comment, subscribe. Thank you for hanging out with me while I read this document and react. It's a little crazy what's going on here. All right, so the investigators, 19. The investigators attempted to interview both Mitch Westerman and Robert Fortson. Both of them declined to be interviewed. 20. Shortly after investigators attempted to interview Robert Fortson, he took his own life. After investigation into self-unaliving, law enforcement, an investigation led law enforcement, to find out that shortly before he lost his life, he had expressed concerns about the open investigation concerning the discovery leak in this case and stated to someone that if he just came clean, all this would go away. So what does that mean? I think there's something way bigger than we all even realize going on here. Because that's, I don't know what that is. That's something to really ponder. The fact that he took his life and then said that all this would go away. Makes you wonder how involved he was in the leaks and how involved he was in spreading the information and what he actually knew, who he was talking to. I don't know. I feel like this whole thing, there's just a really wide-reaching criminal something or other going on in this state and in Idaho and everywhere else. All right. So 21. That a search warrant on the iCloud account of Mitch Westerman revealed screenshot photos of conversations between Mitch Westerman and defense counsel Andrew Baldwin, wherein they candidly discuss the Richard Allen case and candidly talk about the court and the state, displaying a free flow of information that is protected by the court's gag order and the order protecting discovery. I get what he's trying to say here, but if Mitch is a consultant and has been used as a consultant in the past for Andrew Baldwin, there's no reason why he couldn't talk about this case with with Mitch as a consultant if he's working on the case. I mean, even if he's not being paid and doing it pro bono, he could still be, Andrew could still be going to Mitch Westerman on a consulting basis for this case. And that's why he's talking to him about it. I don't know. I'm trying to, play devil's advocate here, trying to, look at both sides. He could have been giving information away. I don't think so. The way that they've zealously fought for their client in the Frank's motion and all of that, I don't think that Andrew Baldwin or Brad Rosie have any ulterior motives or anything other than justice and trying to find the truth. But I don't know. All right, so number 22. That the investigation shows that defense counsel failed to secure evidence and discovery materials in this case, specifically graphic crime photos, which were then distributed to the public and put on the internet in violation of the court order dated February 17th, 2023, and evidence supports a conclusion that the disclosure was ongoing. So they're really trying to hammer out that there was a lot of leaks, a lot of ongoing conversations and things of that nature. 23, that on October 19th, 2023, and again at the hearing held on October 31st, 2023, David Hennessy, attorney for Andrew Baldwin, suggested to the court that both attorneys be sanctioned for their actions. Those sanctions have yet to be addressed. So sanctions are basically like just a punishment. Supposed to be punitive. Usually it is monetary. So if an attorney is sanctioned, they usually have to pay the court whatever amount, or pay it to charity, or pay, whatever the stipulations are, they have to pay an amount to the court. Most likely. Most sanctions are monetary, but there's other forms too. So 24, that the state was notified in the beginning of the leak by the defense by the families of the victims. Since that time, the state has had an opportunity to talk to the families of the victims about the photos and information that was leaked. The amount of harm and re-victimization that this has caused the families of the victims is immeasurable and incurable. I get that. 25, that the press release and the two occasions of leaked information show a trend by defense counsels Brad Rosie and Andrew Baldwin of not being completely honest with the court, violating the court's gag order set in place to protect the integrity of the case, and failing to comply with the protective order we put in place to protect the discovery in the case. Wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland, and swears under the penalties of perjury that the information above is true and accurate to the best of the state's knowledge, based on filings, personal knowledge, and police investigations. The state asks the court to issue a rule to show cause order based on this information and set this matter for a hearing, and order attorneys Brad Rosie and Andrew Baldwin to appear and show cause, if there be any, why they should not be held in contempt by this court. Signed, Nicholas C. McLeland, prosecuting attorney. And here is the press release that went out back in, December of 2022, the 1st of December, and then the next day the gag order was signed, I believe. That's what it sounded like in the article. All right, so press release. As Rick Allen's attorneys, we have received multiple requests from local and national media for interviews and comments since the unsealing of the probable cause affidavit. It would be virtually impossible to comply with these requests and continue to focus on the merits of Rick's defense. Therefore, we offer up these thoughts. We do not want to try this case in the media, and we intend to adhere to the Indiana rules of professional conduct that provide guidance and pretrial publicity. However, The police and prosecutor's office have conducted many press conferences over the 5+ years of this investigation and following our client's arrest. On the other hand, Rick's ability to assert his innocence has been reduced to only one short post-hearing press conference. So that's a big deal. I mean, that's huge in comparison that the state has had 5+ years to paint a picture of what a monster this person is. And then when you have him in custody, he can't say anything to defend himself? That just doesn't make sense. So I wouldn't like that if I was in that situation. On the other hand, Rick's ability to assert his innocence has been reduced to only one short press conference. Accordingly, we feel it appropriate, necessary, and within the bounds of our rules of professional conduct to make a few comments concerning the probable cause affidavit for Rick's innocence. Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life. He is innocent and completely confused as to why he has been chosen or charged with these crimes. The police did not contact Rick after Libby German and Abby Williams went missing. Rather, Rick contacted the police and voluntarily discussed being on the trail that day. Like many people in Delphi, Rick wanted to help any way he could. Rick contacted the people to let them know that he had walked on the trail that day. The police. Rick contacted the police to let them know that he had walked on the trail that day, as he often did. Without Rick coming forward, the police probably would not have had any way of knowing that he was on the trail that day. So that's also very important. They only had their eyes set on him because he came forward to provide information. All right, so Rick volunteered to meet with a conservation officer outside of the local grocery store to offer up details of his trip to the trail on the day in question. Rick tried to assist with the investigation and told the police that he did recall seeing 3 younger girls on the trail that day. His contact with girls was brief and of little significance. And this is 3 girls, not 2. So I don't know who he was seeing, but there were other people on the trail. It wasn't just Rick and Libby and Abby. There were several other people on the trail that day. It was a nice day. A lot of people went out that day to walk and to go be out in nature. Because it was a February day and it was warm enough to go and do things. In the Midwest, that's a big deal. So Rick does not recall if this interaction with the conservation officer was tape recorded, but believes that the conservation officer scribbled notes on a notepad as Rick spoke to him. After Rick shared his information with law enforcement officials, he went back to his job at the local CVS and didn't hear from the police for more than 5 years. So he gave his statement years ago. The next time Rick heard from the police was in October 2022. This was approximately 2 weeks before a contested sheriff's election and within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second-in-command, Michael Thomas. So there were some political things going on behind the scenes. In the lawsuit, Thomas claims that he, Thomas, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation, but those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared that the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year won the 2022 election for sheriff. And furthermore, Thomas claims that he was also removed from high-profile cases. Rick was ultimately arrested on or about October 28, 2022. In the 5+ years since Rick volunteered to provide information to the police, Rick did not get rid of his vehicle or his guns, nor did he throw out any of his clothing. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued with his normal routine. The probable cause affidavit seems to suggest that a single magic bullet is proof of Rick's guilt. It is a bit premature to engage in any detailed discussions regarding the veracity of this evidence until more discovery is received, but it is safe to say that the discipline of tool mark identification, ballistics, is anything but science. And I talked about that in another video. Ballistics is junk science. It just is. I don't know how you can prove how bullets have the same markings from one particular gun. It's just, there's no way that you can prove those things. And I don't want to get into a big talk about that. But anyway, so the entire discipline has been under attack in courtrooms across the country as being unreliable and lacking any scientific validity. We anticipate a vigorous legal and factual challenge to any claims by the prosecution as to the reliability of its conclusions concerning the single magic bullet. So remember, they found one single bullet at the crime scene near one of the girls or under one of the girls, and they're claiming that it belongs to Rick. It came from Rick's home. It's the only evidence that they have to tie him. And ballistics is, like I said, junk science. It's not real science. So when they say that they have this magic bullet, it really isn't, because that's the only evidence that they have against Rick, and it's not really strong, in my opinion. But if you get an expert on the stand and who tells the jury one thing, that, you know, ballistics is reliable and yada yada yada, you know, they're really going to have to refute the expert, because jurors, a lot of times, they hear one expert and they think, oh, okay, that makes sense, and then they hear another expert who totally contradicts the other one, and then they don't know what to believe. So it's really important that we don't bring in this junk science, or at least we scrutinize it much more than just saying, yes, this is a bullet that's consistent with a bullet that would have been found in Rick's home. Because consistent with and proving without a reasonable doubt are very different. All right, so moving on Rick's behalf, we argued to have the PCA unsealed. So they wanted it unsealed. Apparently, it was their call because there was so much questioning about it, and with these gag orders, people's theories and conspiracy theories run rampant. So I'm sure they did want to get it out so that they could at least tamper some of those rumor mills. So Rick had nothing to hide. As importantly, we were hoping that we would receive tips that would assist us in proving up his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all of which will be vetted by our team. Although it is the burden of the prosecutor to prove Rick's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation concerning Rick's innocence. We appreciate those who have reached out to support his cause. So it appears his attorneys believe he's innocent. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killing, yet there was no mention in the PCA about a second suspect. The defense is confused by such discrepancies in the investigation and will be in a better position to respond as more discovery is received. Rick Allen owned a Ford Focus in February of 2017. His Ford Focus is not in any way similar to the distinctive look of the PT Cruiser or Smart Car that was described by the witnesses. So no one ever said that they saw Rick Allen's car. because the timeline doesn't add up. He was likely gone by the time the girls were taken, or he wouldn't have been, he would have been like on his way back to his car by then, at least, if not already gone and back to work, because he was on his lunch break, and decided, because it was a nice day, he'd go for a walk. So it seems that the CCSD is trying to bend facts to fit their narrative. The district attorney's office, I think. That's who they're saying. Who's the SS? I don't know. I don't know who the SS whatever is. They don't, or CCSD. I don't know. Moving on. At this point in time, we have received very limited information about this case and look forward to having something more to review. Moving forward, it is our intent to scrutinize the discovery as it is received and give the necessary attention to the volumes of tips that we are receiving. To the extent we continue to discover information that points to Rick's innocence, we will offer up this information to the public, so long as we are not prohibited from doing so as a result of a recent request by the prosecutor for a gag order, or by the Indiana rules of professional conduct. So they're trying to say, because there was a gag order or whatever, well, it hadn't been put into place yet, but it was mentioned that the prosecutor wanted to put a gag order in place. So they put out this press release, and then the next day, Judge Gull puts out the gag order because she doesn't like what they're saying or something. I don't know. I don't think there's anything in here that is anything but, them trying to change the public perception, not crucify their client before trial even begins. I think that's what they're trying to do. I mean, I get it. Everybody hates the defendants, but as you start to look into these cases, you start to realize that there's a lot of things wrong with our justice system. And even if the defendant's guilty, they still have rights and deserve to be given those rights and to have those rights upheld even during the court process, especially during their trials and proceedings, because that's what can get them out or get them put in jail or give them the shooting squad. I mean, whatever the situation is, it's that jury, those people are deciding their fate for them. I don't know. And when the entire world is being told your client's a monster, I think you have a right to come out and counter it, but that's just my opinion. What do you guys think about that? Please be sure to like, comment, subscribe. Thank you so much for joining me, and I hope to see you next time. Take care. Have a good one. Bye.